Okay, ladies and gentlemen, we're here today on Subcommittee for the Judiciary. We have a couple of bills on the calendar, House Bill 358 and House Bill 405. If you would, let's bow our heads for prayer, please, before we start. Most kind and gracious Heavenly Father, we thank you for the opportunity to be here today. We thank you for the opportunity to serve this great state. We pray your blessings on all the things that we do. We pray that everything we do will be pleasing to you. Please forgive us of all of our shortcomings. In Jesus' name we pray. Amen. Amen. We can start now. We got the judge here. Okay, Representative Seltzer, if you will tell us the LC number and the House bill that you're working on.
Thank you, Mr. Chairman. House Bill 358 LC version 280109 is what was originally filed. That's what I'm offering to the subcommittee today.
Okay. And tell us about the bill.
Well, Mr. Chairman, again, I appreciate the opportunity to present to the committee. This is an issue that, as you step back from it, you recognize in the checks and balances of the three branches of government, executive, legislative, and judicial. There are, as we all know, this gets back to middle school social studies. You know, the legislative branch is the lawmaking branch. The executive branch executes those laws, and in those circumstances that we refer to broadly as emergency powers, because of extraordinary circumstances, prerogatives that need to be given to the executive that stray outside of the bounds of the traditional executive prerogatives are needed to effectuate, and defend our state in states of emergency. We also know that those emergency powers are largely vested in governors. Those are not typically presidential powers. There's in our compound republic, certain powers are presidential, but as we know, emergency powers are typically associated with state gubernatorial authority, and that is also consistent here in Georgia. But as we look at this, and as we've studied our state emergency powers, and as you look at the statutes, there've not been a lot of changes to this statute over the decades. You think about even things like Title 16 are criminal laws, many of which go back to the founding of our state. There are oftentimes tweaks to those that address case law, things that come out of our courts. But our emergency power statute is not something that as a legislator we address all that frequently. And comparatively, there's been in terms of the main thrust of 38-3-51, there's not been a lot of change over time. I think there was, if you had asked someone 10 years ago, what ought 38-3-51 be, I think some of the same kinds of questions could have been raised. It just never rose to the attention of folks. It never rose to the attention of legislators to make it a priority to act on. It was always something that tended to be perennially in the future. Okay? What's the right checks and balances in an emergency circumstance to make sure the governor has the powers they need to defend our state in any number of circumstances, from a pandemic outbreak like we saw with coronavirus, to some kind of invasion, to acts of terror that some states have seen. Thankfully, Georgia is not seen, what New York and Washington D.C. saw, but 9/11. But it's as broad as as disaster could be, and the governor's powers as a result of that need to be expansive. They are defined. There are some contours and some definitions about what the governor can and can't do in a public health emergency versus other emergencies. This legislature acted to limit the governor's ability to limit the possession of firearms and ammunition. That's happened within the last decades. There have been some tweaks to it, but by and large, the statute's not been heavily addressed over the last decade or more. And what HB 358 seeks to do is to strike a balance that I think most legislators likely believed, had they not been reading the statute itself. Most legislators would have believed that when an emergency declaration is approved initially by the governor and then it's ratified by the legislature, that it would be approved for some date certain of time. There'd be some period of time that the legislature would need to come back and reconvene to extend it. And there's also a belief, I think, among the legislators when we faced this back in March of this year, that the legislature could, within the broad powers the governor is given, in 38-3-51, there'd be some ability to limit the scope in a way that's appropriate to the disaster at hand. And we can imagine if there was some kind of a terrorist attack that led to some conditions, heaven forbid what those would be, that the powers would be more prescribed to address those. Or in the case of a public health emergency, although the governor's powers would need to be broad, and the legal, the limitations on the governor's powers would perhaps need to be again, prescribed to fit the emergency and the conditions on the ground itself. Potentially those could change over time as you go through 30 days, 90 days and beyond. Perhaps those could even change and evolve. They could expand or contract. But the idea that the governor has broad powers well beyond what a governor would normally have to address emergencies, I think most legislators believe there is more tools in the legislative toolkit to prescribe and put the appropriate boundaries on those than actually exist in Georgia law. And Mr. Chairman, if it pleases the committee, I'd love to walk through and talk about some of those specifics and how 358 seeks to address that. But the broader issue is what legislative oversight and what legislative involvement there is in the terms and the duration of an emergency power declaration, and how legislators might be able to prescribe a more limited scope for a more limited emergency, so that the powers are prescribed as broadly as they would need to be, but wouldn't be as expansive of any number of emergencies that the emergency powers law currently gives.
Okay, yes, go ahead.
So as we walk through the second page of the bill, line 26, the current statute provides that the governor, upon declaring an emergency, the legislature convenes at 8 a.m. on the second day following the declaration, which means the legislature's has to convene very quickly and has to ratify or not ratify the emergency. So as you think about this, when the governor declares it, he has just a 2-day window before the legislature convenes and says, okay, are we going to allow this to happen or not? That's a pretty quick turnaround time. That's hard coded in our existing statute. So the time that the legislature is engaged is not a concern in my view. And it is very, very narrow in terms of how long the governor has before the legislature has to speak to the emergency. But then once the emergency is in place, it goes on to say the state of emergency should continue until the governor finds the threat of danger is passed, contemplating a shorter period of time. No state or disaster may continue for longer than 30 days. And it says, unless renewed by the governor. And as you unpack this, you think about this separation of powers. The legislature is basically suspending a broad number of our laws and giving singular power to the governor to address the emergency. But the idea that the governor themselves would call an end to this, or there's a convening of the legislature to stop it if that was the pleasure of the legislature. As you unpack the mechanics of that, that's really what this gets at, is the mechanics of the legislature convening requires presiding officers in 2 chambers, or requires the members of both chambers with a 60%, a 3/5 supermajority to act to convene that. There's 4 steps that are required there. There's the members of the chambers, there's the presiding officers of those chambers that all have to come together in unison to put a stop to the emergency declaration, unless the governor should choose to do that. That seems to kind of cut against the expectations, I think, of most of our members, was there was going to be some date certain in which they would end. It's certainly not my interest to address this to our current governor or any particular future governor, but just broadly speaking, you think about the war powers that our president has. Our War Powers Act says the president has 90 days to act in response to a contingency operation, but within 90 days, Congress has to convene by resolution to ratify that to continue, or it technically stops in 90 days. That's kind of consistent with what we're looking at here. Whereas the president exercises war powers, our governor exercises emergency powers, not war powers. But shouldn't our law be consistent with that in some way? And as I was unpacking this, I look at what our statute states. I look at it with the way other states are even seeking to address this in legislation. Mr. Chairman, there are more than 200 bills in the 2021 session of the legislatures across across the country that are looking at this issue, not to mention things that were addressed in 2020. Other states are looking to put a limitation ranging from 14 days on the low end. Most of those are in the 30 to 60-day range. One bill in one state says a maximum of 120 days. But as you look, most of what's being looked at by the legislatures is at the sort of the 30 to 60-day range that could be renewed any number of times by legislatures. And what this bill proposes is that, we wouldn't change this 2-day convening of the legislature by the governor, but that for an extension of the emergency powers, we could extend it 90 days at a time. We could reconvene and extend it for any number of 90-day durations. It could go on for a year in 90-day segments. But because of changing conditions on the ground, shouldn't the legislature, recognizing the powers the governor has, the broad powers the governor has under our Emergency Powers Act, shouldn't the legislators extend those for 90-day windows and revisit it every 90 days? So that, again, as we talk about later in the bill, perhaps the legislature could speak to the provisions and the emergency powers that are given. We know just from coronavirus itself, and this is not a coronavirus bill, by the way, this is a bill for the years and for the decades, but under coronavirus itself, the conditions of uncertainty at the very outset, I think one could recognize that perhaps the governor's power should be expansive because we don't really understand even the contours of the issue and where it's going. But as we move through the months, our governor, I think, was very skillful and appropriate in changing the conditions in which businesses were closed, in which businesses could open, the public health conditions, access to schools, the circumstances in which people could visit in hospitals. All those things were changed by our governor in a way that I think was laudable, candidly. But as you think about our current structure, should the legislature have not had some ability on a quarterly basis, every 90 days, to be able to visit that and make sure that the direction of the executive branch, given the vast powers they have, are not appropriate to the purposes for which they get granted the emergency declaration. So that's what this does. In essence, it allows there to be any number of successive additions to the emergency powers, but it ends after 90 days at the most. So that automatically, so the legislature has to act to extend it, as opposed to its current status as it just runs indefinitely until the legislature should try to convene and stop it. And if you think about the things that are involved in doing that, it's a pretty complex process to convene, have presiding officers, one of whom is elected statewide, one of which is elected by the body, and then the members to act. There's a lot of parts and pieces that if potentially some governor 10, 20, 50, 100 years from now, whenever, were to be able to engage players in the process, the governor themselves could stop the process of convening from happening fairly easily. And there's some examples we could speak to that. I don't want to get into he said, she said, or too many hypotheticals, but it would be pretty easy for a governor that wanted us to go indefinitely to stop that process, versus what this would create is he would stop after 90 days and it could be extended any number of times, but the legislature would have to act in a definitive way to authorize that because of the vastness of these powers.
And that's unlimited 90-day extensions.
Any number of 90-day extensions. It could go on for 20 90-day extensions, but the legislature would have to visit it on a quarterly basis. Otherwise, it would terminate and emergency powers would end. Okay. And again, I think that allows the legislature to be engaged in that process, but still gives once it's authorized, the governor has 90 days to exercise those powers broadly as they see fit, which is, I think, appropriate based on the nature of the emergency. The second provision, Mr. Chairman, this is something else that I think many of our members believed we had. There was even some discussion among the legislative bodies this past March. Do we not have this? And I think we found that isn't. We don't have this authority as a legislature. The idea of what I call a dimmer switch. With the lights are on, the lights are off. There's either an emergency declaration and all the emergency powers are available to the governor in spite of the nature of the emergency, or the legislature says, no, we don't approve the emergency declaration and there's no emergency powers. As I look at this, what lines 37 through 39 does, it says subject to any limitations which may be prescribed by the General Assembly in concurring with the declaration. And then the governor shall have and may exercise for such period those emergency powers. So what this allows the legislature to do is to say, yeah, we approve either this emergency declaration or this 90-day extension subject to these provisions. For example, if we saw the direction of coronavirus moving in a direction where, okay, we don't believe as a legislature daytime curfews were appropriate. Daytime curfews were never imposed by our governor, but the idea of daytime curfews and perhaps closing churches or the legislature could say, hey, for this extension, because we've gone through this, we understand the nature of this, we don't believe daytime curfews are appropriate, so we would approve, hypothetically, a 90-day extension, but daytime curfews need to end. We could put that provision, and there's no mechanism for us to do that under our current emergency powers law. So you think about the shot clock and the dimmer switch. This allows, I believe, the legislature to play a role in establishing the duration in some conditions, but still gives the governor the flexibility to exercise those powers as broadly and as diversely as he would need to. That's the bill, Mr. Chairman.
Okay. Mr. Belinsky, what number are you? 11? Okay.
Thank you, Chair. Chairman Setzler, thanks for this bill. When we first declared a state of emergency, when we had that vote, I remember the conversation was that we were discussing coming back and having a emergency session to remove that authority. There was a possibility of that, and obviously COVID has been probably worse than I think most of us thought, and we stayed in that state of emergency for that reason, so the governor could act in the proper manner. My question is, though, was the understanding that we could come back to a special session and remove these emergency powers? After reading this, did it turn out not to be true that we could have done that? Do you remember what happened? And
yeah, I think the posture we were in, Representative Walensky, I appreciate the question, was a policy of general consensus. And I think when there's broad consensus among legislative chambers, legislative leaders, the governor, I think this all works fine. And I think there was a broad consensus that we'd come back in June and reconvene on this issue. We did. We actually had a special session to pass some legislation that was appropriate to this. But had there not been broad consensus, had we been in an environment of divided government, which can sometimes serve the people very well, I can imagine a circumstance where legislators and the executive branch wouldn't be necessarily simpatico, such that legislators may not be willing to support an emergency powers declaration. And what I don't want to create is a circumstance where it's an all or nothing thing. It's a complete grant of power to the governor. There's a recognition that one legislative body, for example, couldn't stop it themselves if they needed to, if they felt like the governor was sort of running out ahead of where they were comfortable. So there might be a posture to say, we're not going to approve an emergency powers declaration in spite of there being an emergency, because we can't in any way constrain the powers the governor exercises, or even the duration in which the governor exercises those powers. So my concern is, we were all sort of simpatico this March, and that worked well. My concern is, if there were differing philosophies, we might not even be able to exercise emergency powers because of those disagreements.
thank you.
Okay.
Can I ask another question?
Yes.
So right now we're in a state of emergency still.
Mhm.
And if the state house met to remove those powers and there was a majority vote to end the powers, would the emergency order end?
No,
Or
sir.
we would need the Senate as well.
You need to have the Senate convene and the House convene. If the presiding officer in the House, hypothetically, were not to want that, it would take 3/5 members of the House to even convene the House. Let's say the Senate wanted it to end and they voted for it to end, but the House did not want it to end. It doesn't end. It requires the convening, the nature of convening the legislature, but for a 3/5 supermajority in both, requires the presiding officers in both to agree, and then the members to be able to vote for that. So it requires members and presiding officer in both chambers. It takes 4 pieces all to align to stop it.
And 2 more questions, if I
Sure,
may.
sure.
So under this scenario, lines 26, 27, the General Assembly would have to convene and it would be just like a normal bill, a majority vote?
Yeah, what would happen is the emergency powers would end after 90 days. They would automatically end. And then the General Assembly would have to pass another resolution to extend it. So right now it defaults to going indefinitely until either the governor stops it or all those forces come together to stop it. Its default is that it runs indefinitely. This bill has it stop automatically after 90 days, which would mean there would have to be discussion and involvement with the legislature to discuss the terms, discuss the duration, to extend it again. So it's an automatic stop on that.
Yeah. I love giving full power to the House of Representatives. I think we should always do that. But here's two thoughts. I think one of the things we were concerned about when this first happened and going forward was that could we convene? And in the first months after this, 90 days out, I don't think we would have been able to get enough state reps to the House to vote due to this COVID and we may have more of these situations. So I think what I would request here is that, and then I think also from a planning standpoint for a governor who's trying to deal with an emergency like this one that's lasting over a year. How long has it been? A long time. This would, I may be wrong. Never been a governor, but this sounds like he would have to only work in 90 days increments, which could cause problems. Could it be better for it not to run out automatically and just have the powers be in the General Assembly to stop it instead of having it keep running out every 90 days?
Well, that's exactly what the law says today. It runs indefinitely until the General Assembly decides to stop it. What I'm presenting though is the mechanics of stopping it are such that if any one of those four components, Senate members, House presiding officer, Senate presiding officer, if any one of those four is not committed to stopping it, it can't stop.
The way I read this said that the Assembly would have to meet to vote to keep it going.
Yes, and what the bill proposes is the emergency declaration would stop date certain, which would require the General Assembly to convene, to vote to extend it. And we could extend it for 30 days, we could extend it for 60 days, we could extend it for 90 days. We could not extend it for 91 days. But that if there's, again, as long as we're maintaining broad consensus about the terms of the emergency powers, there would be the expectation if we're in something like coronavirus that we can see the arc of it. We know it's not going to end in 90 days. You approve 90 days, you know it's not going to end right away. And we get in a rhythm to be able to do that. The challenge is without that, there's so many things that can prevent a stop to it that it's a concern to mine. Once it gets started, it's on cruise control. And it's hard to stop. You don't just tap the brakes. It takes a lot of things to make it stop.
One last question.
Yes, sir.
Thank you. I agree with you 100%. There is concern. And I think a lot of us agree that we don't want, once we give powers to the governor, for those to not be able to be taken away, too complicated. And I understand the scenario you're saying. My concern is with just 90 days. I think my issue is that, especially during an emergency situation like we had, I don't think we would have been able to return within 90 days and have that vote. So maybe extend the days or something that doesn't have it run out automatically, if I'm reading it correctly.
Well, I appreciate the question. We had to convene within 2 days. I mean, it was called on a Saturday. The way it was staged, it was, hey, this is going to happen. The governor issued the call on a Saturday. We came in on a Monday, so at 8 o'clock in the morning. So we convened to do that. I think it's a false premise to assume the General Assembly can't convene, but because the statute requires us to convene for the governor even to have any emergency powers. So if we can convene in 2 days, I would contend we can convene within 90 days.
Okay. Chairman F. Strachan.
Thank you, Mr. Chairman. Thank you, Chairman Setzler, for your presentation. I want to get into the mechanics a little bit so that I can fully understand what just how this would work specifically. So there would be no change to the fact the General Assembly must meet within 2 days, the second day at 8 a.m. following the declaration. And then as I read this, there would need to be another meeting, concurrent meeting of the House and Senate within 30 days for the extension. And that extension would be up to 90 days. Is that correct?
Correct.
Would it be possible on that second day after the state of emergency for a concurring resolution be issued, giving that extension for the ensuing 90 days?
There wouldn't be,
Okay.
No.
The,
to my knowledge, unless I'm missing something that you've caught.
all right. The, and I guess, you know, the language that I'm curious about is the concurrent resolution language. I assume that that's concurrent House and Senate.
Yes.
And if
It does not require a signature of the governor, but the House would pass the same language as the Senate.
but it wouldn't be, and I'm asking my second question. The reason that I was wondering about this is would you be opposed to a circumstance where in that initial session of the special session of the General Assembly where the state of emergency is approved, that there be a longer period of time within which the governor will be authorized to execute those emergency powers, and just what your thinking is about that, why it may be necessary to appear within 30 days and then extend for 90 days.
The statute, I believe, contemplates an emergency that's going to be over in a week or so. So something awful's happened and it's going to subside and we'll be back to normal. I think as I read this, I think there's a deference to getting things back to normal and not having year-long emergency declarations. Having said that, I think the 90-day window, I'd be comfortable just as an author of this, as a proposer, that when we authorize on the second day that term, I'd be comfortable for the initial term to be 90 days. I don't have any issue with that at all. I think this contemplates the term being very short because I think there's such a deference to getting back to normalcy. But I have no issue with it being 90 days. I think the fact when you look at this, they're looking at a 2-day convening. 30 days is kind of like how long it would need to last typically. It contemplates the governor extending it. I think they're thinking in terms of weeks, not months. I think we tend to think in terms of months, and we've been conditioned that way through the coronavirus duration. In my sense, again, when you're looking at this, you're making law. There's no law to follow. What analogies do you have? I think about the war power. That's why I want to use the war powers framework of 90 days. Now, granted, once they authorize a resolution, the execution of a military operation can extend for long periods of time. But I think the nature of that is different than the emergency powers that affect our citizens at home every day. You think about the ability to constrain travel, limit people to limited physical spheres of travel themselves. I mean, the powers are expansive, and I don't think we can constrain the powers themselves easily because the nature of the kinds of emergencies we can have. That's where I think what's the appropriate level of legislative involvement in just as a check-in for the governor to say, how often do we need to check in to make sure that these vast powers we've given the governor, the conditions are essentially the same and they need to go forward. So in my sense, every 30 days, I met with the governor about this, we talked about 30 days. I think he thinks with all that the governor does, a 30-day bill would just be too choppy. We'd be coming in all the time. It would be a distraction. The negotiations, even with the legislators about the terms of this, could be a distraction for the executive branch. I'm concerned when you go beyond 90 days, you're talking about 4 and 6 months. That's half of a year that we're just sort of granting powers to a governor. I think to me, 90 days is a sweet spot that I feel comfortable with. And I think that would probably be an appropriate, if you wanted to put a limitation on that initial duration, that would probably be an appropriate initial duration as well.
Well, and I would just note, my recollection was approximately 90 days from when the declaration of emergency was made until we did return in June. And this really goes to the question Representative Walensky was asking, but the terms by which the General Assembly may meet, is that something that is within the purview of the General Assembly to determine in that initial session 2 days after the state of emergency is declared? In other words, could the General Assembly authorize rules to meet in a way necessary to renew this if necessary, meeting by other means, things like that?
I think we would have the power to decrease the threshold. Right now it's 3/5 to meet. I mean, right now, if you think about the rules of our body, if the chair calls for a vote by voice, it only takes a 2/5 vote to say, hey, let's divide the question, or let's have a show of hands. You know, there are some things that give pluralities powers to do certain things. I think we could give power to a individual legislative body with a lower plurality than 3/5 by statute. But I don't think one legislative body can bind another body. I don't think the House could convene and force the Senate to convene. So it's still a two-part issue. That if you had divided government, maybe this body's with a governor, this body's not with a governor, and you could once again, even if we simplified that by taking the presiding officers out of the question, you still have this issue of you don't have the kind of this broad kind of plenary legislative power able to be exercised unless the governor's got to come back to the legislature to consult and exercise that. So I don't think my concern is 4 parts is problematic, 2 parts is problematic, and divided government can put us in a place where we can't do things we need to do because of those divisions.
And my final question is, what are your thoughts as to the importance of the General Assembly actually convening physically? So, you know, we're going through this terrible pandemic and there are concerns about members being here. But what thoughts do you have about the importance of actually physically being at the Capitol or calling a session to consider these matters? And what consideration did you give in drafting this bill as to the nature of the meeting that would take place?
In some ways, that question can take us outside the 4 corners of this bill. That's a broader question of the General Assembly. You know, are we able to meet remotely, long-term, outside of an emergency declaration? As we approach this, we're inherently going to be not in an emergency. So we're in normal conditions. It's my belief that no, an emergency could have happened. It's my belief that General Assembly convening in person is appropriate. I don't say that just because I'm closer to the Capitol than others, and we have highway patrol. We've got resources to help get folks to the Capitol. So I'm comfortable with a requirement for the General Assembly to convene. Now, having said that, if we want to venture into a remote meeting and what that can mean, I don't know that we've written, if that's been fleshed out adequately to memorialize that and to put that in code. I'm open to the will of the committee and the legislative process to that. I'm not concerned that members can't get here, given the resources of the state, and given the impact of this, and given the need to be able to deliberate. Because a lot of this, if you think about this, it's not just having a meeting like a hearing today, or we've had a chance to pull this bill down on the internet and review the bill, deliberate over the bill. You know, in a circumstance of an emergency, I would contend that the physical presence of being able to convene together, talk to other members, in that face-to-face discussion in very uncertain times is meaningful. I don't know that could happen over Zoom, because it's not just the meeting that chairman administration calls. It's the informal discussions among legislators an hour before this meeting to discuss ideas. And I think that coming together is important to me. But I mean, that's going to be the will of the legislature, how they would address this as this moves through the process. But I don't want to be doctrinaire and say it's as an author, it's a deal killer. I didn't think we had to take that issue on in this bill necessarily to address what I do think is a pressing issue of duration and scope.
Representative Dry.
Thank you, Mr. Chairman. Chairman, thank you for bringing this bill. You know, along with you, when this occurred early on, I was concerned about broad powers, and with a lot of things in politics, people have acted in good faith in the past, and we hope they continue to act in good faith in the future. And this governor acted in good faith with his emergency powers, but that is not a guarantee at any point in the future. And the other thing, when I came here that day to vote on the emergency powers, I realized it was one of the most important decisions I'll make as an elected official. And I didn't feel good leaving. I felt like I did the right thing, but I also felt like I abdicated some responsibility. And there was a patchwork around trying to make sure that something didn't happen, power wasn't abused, but it was not adequate. by any means, even though we worked in good faith among the parties to put that together. And there could be a situation, I don't think it'll be in the next 2-4 years, but there could be in a situation 10 years from now during an election with emergency powers that we could lose a lot. And with the way this system is set up, we are abdicating responsibility with no way to reasonably be able to get that back. So thank you for bringing this bill, Mr. Chairman.
Okay, thank you, Chairman Burchett.
And Mr. Chairman, to just a quick highlight of his point, I think we as legislators, I think many people had that same uneasiness that you had, and we made the best given the law as it was then. The question is now that we're past that and we're in a legislative session and we can affect how the law is moving forward, aren't we also advised to do something about that? Because we can impact what the next ones look like.
Okay. Go ahead.
Thank you, Mr. Chairman. Thank you for bringing this legislation, Chairman Sessler. I just want to make sure I understand the bill. So the intention of the author is that any emergency called by the governor can only last for 90 days or 30 days, excuse me, unless we convene as a body, the legislature convenes as a body and extends it for up to 90 days. And then we'd have to convene every 90 days. You're not messing with how we convene, just that we must convene. Given this pandemic, it seems to be, I felt the same uneasiness leaving. So I'll say that, but it seems it would be tough. I share in the anxiousness and that it would be tough to get into session over and over again with a 3/5. Have you taken consideration of that at all?
Well, again, the 3/5 threshold is what it takes for members over the opposition of their presiding authority to call themselves into session. So if the lieutenant governor was not willing to come back and address this, then it would take 3/5 of the senators. And again, even getting to the 3/5 threshold, there's politics involved in signing your name to the bill to override a presiding officer. There's a lot of impediments, practical and structural impediments to that being effectuated. So again, I think the idea of having a date certain by which it terminates creates a circumstance where the governor has to consult with the legislature for it to be able to continue. And so it mandates legislative involvement and input, but not legislative execution and control. The governor has to negotiate conditions moving forward, which the legislators broadly approve of and authorize them to execute. We're not involved in the execution of that. We're not doing daily checkups. We're not managing a to-do list, but it is a broad framework that the governor would need to come to the legislators to negotiate, versus as it stands today, once it starts, it is. I think, and I can think of some specific examples. I recall in 2007. This is not in the context of emergency powers, but in a similar power, there were the House of Representatives executed 13 veto overrides over our governor's vetoes that had been passed in the 2006 session, had been vetoed by the governor, and the House came together overwhelmingly and overrode 13 in a bipartisan way, overrode 13 of those vetoes. The Constitution says the Senate shall immediately consider such actions. Well, what happened was the presiding officer of the Senate was not, for whatever reason, we can't explore motives, said, okay, the Senate has considered, and we've assigned those to committee where they died. I think the Constitution contemplated they would be voted on by the other body after the veto override was passed by one body, but the quote consideration was to assign them to committee where they died a silent death. So you think about these powers, that is a practical example of, what it really takes. And I think it was just instructive to me of some of the politics that can go on to interdict an action that would stop an emergency declaration, even if legislators were broadly concerned about what was going on.
Okay, thank you for the answer. One follow-up if I may. Actually, going to be two, but and the mechanics, going back to the mechanics of how this would work, if the 3/5, say we had the 3/5 in both houses, we'd sign an affidavit saying we want to convene. Couldn't we, at the way the law stands right now, say like I said, 10, 12 years down the road, we're in an emergency declaration. Couldn't we, with that 3/5 votes, just how the law stands, convene and correct whatever we need to at the time without having this 90-day provision in there?
We certainly could. Our current law provides, as you know, Mr. Chairman, that if 3/5 of the House and 3/5 of the Senate all sign their name to a document calling for the special session, 60% in both chambers could convene for purposes of stopping the emergency declaration. But should it take a supermajority of both chambers to stop an emergency declaration? Or should an emergency declaration have natural limits on it that requires the governor engage legislators to extend it? What's the default condition? As it stands today, once it's authorized, the default condition is that it runs indefinitely till the governor should stop it, or a supermajority stops it. Or on the other hand, should it automatically stop, and then it requires a simple majority to extend it, and what provision? What should the default condition be?
Sure.
So say with a supermajority, it can absolutely be stopped.
So, and this goes to Representative Lewinsky's question earlier. So as I understand it, the Constitution allows us to get to 3/5 to get into a special session. But in a quorum is just a majority. So we could, if we were in a scenario like we are now, where we get an affidavit signed by 3/5 both in the House and the Senate, then we could still come and conduct business with a simple majority, correct?
Yes.
Okay.
Yes.
All right. So
So if you got the signatures, but people couldn't, because again,
they couldn't come for whatever reason.
that's right. You could conduct business with simple majority.
All right. Last question, if I may, Mr.
Yes, sir.
Chairman.
Yes.
The subject, the language in 37 through 39, subject to limitations prescribed by General Assembly, as I understand it, the governor's powers are laid out, his executive powers laid out within the Constitution. Are we running afoul anywhere here, you think?
No, so the governor's powers are largely defined in statute,
Mhm.
38-3-51. The Constitution speaks to powers, but those powers are really creatures of statute, and they're here in the section. So that's where we talk about, and I've not tried to enumerate all those powers and say what could be strained or limited, but in essence, the powers of this that are above and beyond conventional law, that's the scope in which exists now that could be constrained. Obviously, we couldn't by this constrain any other law because we can't bind by resolution.
Thank you, Chairman Sessler.
Judge Gunter.
Thank you, Mr. Chairman. And Chairman Setzler, thank you for the bill. I do believe we probably need some sort of limitations. I take it the governor's office isn't on board with this.
Yes.
They have, when I met with them, and I met with them before I even filed the bill, they have not taken a position on it. And I don't say that to suggest they're fully supportive, but they were just sort of getting into this issue, and they've not taken a stance on it. I think my exhortation to the governor was this isn't a political thing. It's not a partisan thing.
Right.
It's certainly not focused at him individually, because I think I think we have a bipartisan, some consensus in this committee that we felt good about how things happened this year. It's not a cut on anybody. It's just it's a recognition of what the gentleman from Atlanta said earlier was, I think a lot of us left uneasy with the process, not with the outcome that we were moving forward. It was going to happen fine for 2020, but the process, it wouldn't have been the process we would have chosen. Now we're in a time we can affect the process that we would use moving forward. And so I think I would love to think the governor's office can come on board with this, but they're not in a position of support right now.
So I'm similar to Chairman Efstration in the mechanics of this is what I'm trying
Yeah.
to get in my head here. It says on line 16, as a condition precedent to declaring a state of emergency, the governor shall issue a call for a special session. And I wasn't here when that took place before. So is that how this took place? That he issued the call before he declared it, or right at the same time he declared it?
Yes, sir. We were alerted before he made the call. Hey, next Monday, we're going to do a special session. He waited till Saturday to make the call so that this period happened. So we kind of got a pre-notice it was going to happen.
Okay.
And then he issued the call, I think sometime in the afternoon on Saturday, the 13th. And then we convened on 8 a.m. on the 15th of March last year.
Okay. Now, one of the questions I had was how to bring back the legislature on the 90-day runs that you have. If there was language added in here that you convene under the original call, that you would have that the General Assembly would have the authority under the original call in this statute to come back every 90 days. Would that cure the problem? As you see it that way? I'll defer to the rest of the committee on that. And then the other thing is, if we have a governor who's maybe not cooperative and thinks that the emergency should maybe switch. And what I'm thinking of is the current situation. We have the COVID virus, and now we're starting to get different strains of it. So for each one of those, could he call an emergency, state of emergency, and then trigger this statute so that we keep coming back?
That's a great question. In fact, that's an issue that was addressed in some other legislatures. This bill doesn't address that, perhaps it should, is the governor called an emergency, and if that term is ending, they could call a separate emergency, ostensibly unrelated. Hey, we have a new emergency here. It's not pursuant to this emergency. It's not an extension of this one, but it's a new one under different conditions that other states have, in addressing this, have said, hey, the governor can't call another state of emergency, but pursuant to this. So our bill doesn't do that, but we might be advised to do that. That's not something when we initially crafted this that I had thought through. I think that issue had come up in some other states and other legislatures. So I think that may be something we deal with. There's the emergency powers question is on kind of one track, and that it's got to be, you can't have multiple parallel tracks going at the same time. But this bill does not address that. So technically, to your question, there could be an emergency powers declaration that's running, coming to an end, and they could call a separate, unrelated emergency powers declaration that affects many of the same powers and many of the same issues. And, it could be a governor could conceivably, if you follow the thinking, could conceivably gain that system.
Yeah, and that's what I'm thinking of is they could do that. Or since we're talking about, a virus that you can't really see, and another virus comes along totally different than, say, COVID-19, and he would need that authority so you're not suggesting we would have any kind of limitation because they may not know that this new virus is totally different than the one that we've been dealing with. Am I making myself clear?
Yes, sir. This bill does not contemplate taking away the governor's power to call a secondary or parallel. Again, we're running on this emergency powers track. It may be ending in 27 days. The governor may say, I want this to continue, and I'm not liking the way the negotiations are going with the legislature. I'm going to call a separate emergency powers declaration, which may deal with coronavirus plus, COVID-21, or whatever the thing is, and that could run and swallow this bill. So we may be well advised as a legislature to look at emergency powers in general, that you're in emergency power status or you're not, that you can't call parallel emergencies. It's you're in or you're out. That's probably something we need to address in this, but I'd not initially thought about when I did this.
Okay. And back down to lines 37 through 39, and then the similar language that's in the rest of the bill. The concurrent resolution that the legislature would adopt doesn't require a signature by the governor. Is that correct?
That's correct.
Okay. Do we run afoul of the Constitution in any regard for that? Can we limit that as a body with both the House and the Senate in agreement? I guess, would that resolution stand? And there may be some other examples of that out there.
That's where we're using the concurrent resolution language here. That's why that's used. And it's concurring with the declaration of the state of emergency. So the declaration is still the governor's declaration. We don't have the power to make the declaration. We have the power to limit it. But as the structure is now, the governor maintains the power for the declaration. We concur with it, and adopting the concurrent resolution, which is strictly an act of the House and Senate. That's how that existing structure works.
Okay. All right. Thank you. I appreciate that.
Okay, Representative Bruce, you had a question?
Representative Frustration kind of started what I was going to ask relative to how we meet from a practical standpoint. This is supposedly a part-time legislature. People have jobs, people have businesses, and to ask them to come back every 90 days to deal with whatever the situation is could put some people in, difficult situations. And if it's an emergency, it's probably already a difficult situation. So I don't want us to skip over this idea of having these meetings done over the internet, Zoom or whatever. And at the appropriate time, I would actually like to make a motion to amend this to allow for these type of meetings.
Any response?
And Representative Bruce, I appreciate it. I know there's no gamesmanship to this, so I'm not trying to avoid that. I was very forthright with Chairman Frustration. And this is just an honest question and not a leading question. Are there provisions that you know of in statute that contemplate alternate meeting arrangements for us? Because if there is, I don't want to be inconsistent with that. I know we did some things through our rules. Do you know, Representative Bruce?
I'm not aware of anything. If you remember when we met, last session, we voted in the House to allow for meetings to be done over the internet. It didn't pass the Senate for whatever reason, but it did pass the House. And I'm just concerned in a lot of ways that, if we can, if it's an emergency, we need to be able to move quick. And I can't think of a quicker way to move than using this electronic method to meet. If it's really an emergency, what I don't want us to do is to look at what's going on with the coronavirus as the only emergency that exists. Because we're looking at this and we're saying, well, this emergency has lasted a long time. But what if this was the situation up in DC? What if we had an attack on our Capitol? What if we had some other type of emergency that a delay in meeting, even a 2-day delay, could cause, death or destruction of property? My thought is just that if we could, include in this bill a provision that says that we could meet electronically, and I just think that it would help all the way around. If it's a true emergency, you want to be able to have a true and quick way of dealing with it. And I can't think of a quicker way to do it than to be able to meet electronically.
Again, in principle, Representative Bruce, I don't disagree with you. I think coronavirus was helpful in the sense that we didn't have interruption in our power grid. We did generally have internet connection, and it was easy to meet by Zoom. Other disasters might be the power's out and all we've got is, EVs have all powered down. All we have is gasoline fuel, and we drive here or we fly a chopper here. So yeah, I'm
That's
open
why I
to.
say it's an option. I'm not saying we have to do it that way.
Sure.
I'm saying put the option there. So if the power is up, then we can still do it.
Yes, sir.
If the power is down, then if the power is down, probably people not coming anyway. So I think the quickest and easiest way to get a quorum and to get the 2/3, if we need 2/3, whatever, the quickest and easiest way to do that is over the internet. And I think that we need to have that as an option, not a requirement, but at least as an option.
Thank you, sir. And I would not oppose that if that was the pleasure of the committee.
Okay, any other questions from any? Okay, Representative Walensky.
Thank you, Chair.
11. Got you.
Thank you. Thank you, Chair. I'll be quick. One thing that was said, my understanding is this code section in the history of our state had never been used till last year, right?
I did not say, I didn't say that.
No, you didn't say that. I'm just asking. Sorry. Let me start with, I'm going to try not to sound like a deposition, but is it, my understanding, no, I'm saying, but my understanding, this is the first time we've ever used this code section.
In my memory, but I don't know.
Okay. So I'll just say, I was told by everybody, we've never used this code section before. The only time we've used this code section, we've been in a state of emergency for only a year. So I just say, it's slightly unfair to say that this code section will only be used in instances where we'll only be in an emergency for a week, because the 100% of the time we've used it, we've been under the state of emergency for 11 months. So I think we need to make sure this code section is only used in the most extreme cases like we had, and should not be used for short-term things. And I'll leave it at that. Thanks, Chair.
I would agree. Thank you, sir.
And I do like the intention of the bill and hope we can find a way to move it forward. Thank you.
Okay, any other questions? Okay, sorry. Chairman Burchett.
That brought up a question for me. So when we come into special session for, let's say, the hurricane, that was out of another code section?
Yeah, we're talking about Katrina.
Okay.
Hurricane Katrina was a special session Governor Perdue called. We came in, I think we addressed something with respect to price gouging for gasoline. I think Ways and Means Committee addressed that issue, and maybe one or two. So there was a limited scope, but it was just passing general laws to address that.
Thank you.
Okay, I think on line 21, this is only for public health emergencies. Is that correct, Chairman Seltzer?
No, sir. This is the entire emergency powers chapter. So of which public health emergency is a subset.
Okay. I don't think we're ready to vote at this point in time. And let's give everybody a chance to get with Chairman Seltzer and see if we can come up with a final draft of this. And I think we're headed in the right direction. And I appreciate you bringing that today.
Mr. Chairman, I appreciate that. I kept it very, very simple, just so the ideas are clear and there's not misunderstanding about what it's doing. Members come to me if this is, I think if I were rewriting this code section, I wouldn't write it exactly as the bill presents. I'm trying to make a really light touch of how we do it. If it's the chair's pleasure, the committee's pleasure to make some more tweaks in here, I'm open to that, Mr. Chairman, as you guys would desire.
I'll let the members get with you and then we'll get you back up for a hearing.
Mr. Chairman, appreciate that.
Thank you.
Appreciate the opportunity to be with you today.
Okay, Representative Walensky, this is House Bill 405. Is that correct?
Thank you, Chair.
And would you give us the LC number that you're working from?
Yes, Chair. This is House Bill 405, LC 412924S. And
Is there a S?
Yeah.
I don't have a substitute on. I have the original draft.
all the committee substitute did is on line 1, it adds the words to amend at the beginning. So line 1 should read to amend Article 1. And I can hand you this one, but this is the only.
That's the only change in the
It was a
whole.
clearical error by
okay.
the best legislative council Georgia has ever had. in
Okay, we'll
history.
go ahead.
All right. Thank you, Chair. So This is a very simple bill. I think everybody leads off with that.
Okay.
But this bill originated with the Judicial COVID-19 Task Force that was created by Chief Justice Harold Melton and chaired by Justice Sean LaGrua. The task force is a committee of the Judicial Council comprised of representatives from all classes of court, as well as many stakeholders, including the State Bar of Georgia, PAC, GPDC, GACDL, ACCG, and others. ACCG has come out in support of this, and this bill was drafted by the Judicial Council. It's the collective input of all of these groups, work product, and compromise, as well as having the support of the entire Judicial Council. The intent of this bill is to provide options to address the impact of the pandemic on court operations, specifically the backlog of cases due to the suspension of jury trials for most of the past year and socially distanced facilities that will be required for proceedings. So just broadly, all this bill does is allow counties and courts an easier way to have court in non-governmental buildings. The reason it's a repeal and a replace is because in Section C, it makes it a population act. So that's why it's a repeal and replace. There's no sunset. And, we have such a backlog of both criminal and civil. We need to get courts going. And this is just a simple fix to get courts allowed to be a non-governmental building so we can move forward with trials. And I'm happy to answer any questions or proceed how you see.
Okay, any questions? Okay, Judge Gunter.
Thank you. I have more of a comment about a situation I had back when I was a judge. We were trying a serious case in Towns County. And on the first day that we came in to select the jury, there was a bomb threat made at the courthouse. It's a small rural courthouse, one courtroom only. And so the judge decided to take it across the street to the church that was over there, which we tried to tell her that you can't do that. And the case ended up getting reversed because of the time that we spent over there selecting a jury. So an alternate location, I guess my question is, would this be, something previously set up by the local government that they would have a resolution already in place that declares in case of a bomb threat or anything that keeps the main courthouse from being open, that you can move to another location? Does it contemplate that, or is it just
This kind of contemplates what you're discussing, especially dealing with the COVID that we're dealing with now. So lines 15 and 16 has what the law used to be, where you would have to get the governing authority to do so. And this creates exceptions. So it makes it where it doesn't say, anything premeditated or what they're doing in advance, but this gives the opportunity for the superior court or state courts to say that we are going to use this building. And so they can move their courts and trials into another non-governmental building.
okay? But I mean, would it be, I guess it would be a standing resolution by the commission?
What I would ask is, we have a witness judicial counsel who's here, and I think I could answer, but I wanted to make sure we have the exact details because she sat through and did all of these work product together and all of the meetings and all of the negotiations. So I'm sure she could answer that. She's in the hallway.
Okay.
Yeah.
You want to call her now?
Sure. I think that'd be
Okay.
great.
Okay, her name?
Is it on the witness list? Let me
No,
see. Okay.
we don't have a list.
All right. Let me check. Thank you, Chair. This is Tracy Mason from the Judicial Council.
She's the boss of the Judicial Council. Is that right? Go ahead. And tell us what you know about House Bill 405, please.
Yes, so thank you so much for hearing this today. And thank you, Representative Walensky. As the representative explained, this came from the COVID-19 task force as an option to provide some options for addressing the backlog. And it does provide that Superior and State Court may be held in a non-governmental facility so long as there is a contractual relationship between the governing authority and the court.
Okay. So it's got to be within the government's authority to be able to deal with that person or church or whatever it may be, to be able to have, do they have to have a standing contract with the?
Correct. Yes. The language as drafted in line 19 is
Okay.
that the governing authority has a contractual relationship with such alternative location for such use. So that's the new language that we have proposed, is allowing for using those facilities as long as there's a contractual relationship between the governing authority and the facility.
Okay. I think Chairman Administration has a question.
Yes, sir.
Thank you, Ms. Mason. So I just want to talk through how this may work, just an illustration of what this might be. So if say a county courthouse does not have courtrooms with a capability for social distancing currently, that county government could contract with a local facility. It may be privately owned, maybe it's owned by a nonprofit or some other organization, and the agreement would be reached. This would be the designated location for court type proceedings, and that agreement would be between the county and the judicial circuit, I guess, or please tell me. But with that agreement, then court could proceed in this pandemic, for example, court could proceed in a safe, socially distanced location based upon this agreement with a site that's outside of the courthouse. This law would just allow for that to occur. Is that right?
Correct. That is the goal. Is so if you have some of these facilities that, especially during a time like this, that may be vacant, a bowling alley or a movie theater, some of those large sites that have the space, you could spread out for jury selection for the trials. Then it provides that resource. It provides that space.
And is it fair to say that we're maintaining real local control with respect to selection of the most appropriate locations, what guidelines and what would need to be followed for county governments or the court in implementing that safe environment for court to proceed now with this legislation?
Yes, from the legislation provides for the contract between the local governing authority and the facility. So that would be between the local government and the facility. And then as far as guidelines and safeties, as far as logistics, is that what you're referring to?
Yes.
So there have been guidelines that have been published by the task force, by the Judicial Council. A lot of discussion, obviously referring back to CDC and Department of Public Health guidelines. So all of the courts have those resources on hand to operate within the current facilities now, and then should they be set up in some alternate facilities.
I know there's been a lot of talk about the backlog that we're seeing right now in cases, and efforts like this to try to address it, to provide flexibility in the law so that court can proceed, I think should be applauded. So thank you very much for bringing,
Thank you. We
and
appreciate
thank
your
you to the
support.
sponsor. Yep.
Thank you. Any other questions? Chairman Burchett?
I have a friendly question. Just in rolling this out, then in my home circuit there, each county commission would have to pass a resolution and then contract with the alternative site for this to be applicable. Is that correct?
Yes, sir.
Okay.
Yes,
All right.
and the language about the resolution, I believe, is in the current statute. So what the task force has proposed adding is specifically that language about the contract.
Okay. Thank you.
Okay, any other questions? Okay, thank you for, excuse me, Mr. Representative Walensky. Go ahead.
Thank you. Thank you so much, Tracy, for all you do. And I was just going to say, on this bill, we have two of the top judges as co-sponsor in the state, our former judges. So that's also amazing.
Okay. One more question.
Sorry, I didn't ask this earlier, but in the event, so say Waycross, they own an alternative location. So would they need a contractual basis to be within that, what I'd say the city auditorium, because that's where they're intending on doing something like this?
I believe if the facility is owned by the governing authority, then that's not what this is seeking to do, because that is already an alternative that is allowed. So it's
Okay.
again thinking about these private facilities or nonprofit facilities that but the governing authority does not own.
So like the judge said earlier, if that wouldn't be a technicality that someone could get something overturned because it says contractual within this. You're saying somewhere else within the code, it allows for outside of the court, you could go to an auditorium. Is that correct? Is that what I'm hearing?
No, I don't. I'm sorry if I misunderstood. And let me just see. So with it saying that it will be lawful to hold court at an alternative facility, and so as long as the governing authority has a contract with it. So and so if I misunderstood, I think you said Waycross had an alternative facility already.
So you're right. So if they own the facility, how do they contract with themselves?
So I don't think that is what is intended here. If the local government already owns the facility,
Okay.
I don't believe that is what is intended here. I can
Okay.
get back to you on
Okay.
that and just confirm.
Okay, thank you.
Chairman Administration.
What we'd like to do is take a little time to review the bill, and maybe Representative Walensky, you can get with Chairman Burchett, make sure that is addressed, and we have time so that we can bring this back through for consideration next week. Okay. All right. Thank you.
Okay, we have one other question, please. Judge
Yeah.
Gunter.
Ms. Mason, I just wanted to point out, I think on line 25, the Chief Judge of the Superior Court enters a written order. So in that situation where the county governing authority owns the other facility, you still need to get this step done to make that a courtroom or to make that a court. So I think that takes care of any problems that you have about a contract.
Thank you.
Okay, thank you, Tracy, and we'll get you back next week, Representative Walensky, and thank you very much for
Thank you
coming.
very much. Nice to
Sure.
see you all.
Thank you. This committee is adjourned.